Hi, and welcome to Real Estate After Death, where I'm here with my incredible lawyer, Raluca. How are you?
Hi, thank you for having me. I'm good.
What do you do and who are you? Tell me.
My name is Raluca Stoica, and I'm the principal of RMS Estates Law. I practice wills and estates and real estate law in the Greater Toronto area.
Incredible. So, thank you for joining us here. So, what myself and Raluca are doing is we have taken on this initiative called Real Estate After Death, where we'll be talking about all the things that you should know, whether it be estates or what's a will or doing estate planning, everything you should know to set yourself up for success or a loved one. It's not the sexiest topic, but it's one that is critical and one that you shouldn't just know about upon someone's death. So today, we are going to be diving into a two-part mini series where we're going to talk about what forms of home ownership there are. And on the second part, we're going to be discussing and what happens to those types of ownership when someone passes away. So, Raluca, will you please tell me what are the most popular ways that you can own a property? In Ontario, of course.
I would be happy to. So, a person can own a property as a sole owner. So, that means they're the only person on title. This type of ownership is most common for a widower, maybe, or widow or widower, somebody who lost their spouse, who might have been a joint on title, and now they just own title by themselves. It's popular for business owners because maybe their spouse alone qualifies to own the property in their name, and they don't need the other owner, the business owners, to for mortgage purposes. It could be because you want to shield a person away from creditors,
Mm.
and so the only the one spouse owns the property. So that's sole ownership. Then there's tenants. Yes.
Single individuals, I would assume, would also qualify under.
Yes.
So, okay,
That's a good point. Yes, also single individuals that that maybe don't have a spouse, or young adult that just bought their first condo. That's right.
perfect. Okay, go ahead.
The second type of ownership is tenancy in common. So the two owners are tenants in common. What this means is that they have a divided interest in title. So this can be owned 50-50, it can be owned 1%, 99%, whichever percentage the two owners decide. This is a popular type of ownership where somebody gets added to title, for example, for mortgage purposes. So a child wants to own a property, and they need the parent's salary and assets in order to qualify for that mortgage that they're applying for. So they add the parent to title with 1%. And this divided interest means that uh, it doesn't have a right of survivorship. We'll talk about this a little bit more in the second half of this video, but just keep that in mind for now. And then the third type is tenants in common. This is an undivided interest. So together they have an undivided 100% interest. You can't say that one person owns a part of the title or not, because on upon if a person passes away, there's a right of survivorship. And this form of ownership is very, very common among couples. I've also seen it actually among a parent and a child. uh, there's I don't recommend it because it comes with a suite of situations where this joint tenancy could be severed on death or in certain situations. So whenever I see this on title, I always bring the red flags up to my clients. I always bring the possible scenarios where joint tenancy could be severed, but nonetheless, I do see it on title. So those are three popular forms of ownership. There are others. You could use one in common, like you could use the second one and the third one in combination with each other. You could use trusts, but I'm not going to get into that. It's just really high level three types of ownership.
So to recap, sole ownership is one individual, or could it be a corporation?
It could also be a corporation. Yeah.
Okay, so one corporation or one person, one entity owning a property. Then
Mhm.
we have tenants in common when there's two people, but one has a higher percentage of ownership than the second party.
Not necessarily. They could be 50-50, but yeah, it's yeah, if one of them wants to own more than the other, it's possible with tenants in common. Yes.
Okay. And then the last form is joint tenancy, and they have 50-50.
Yes, they have 50-50. Yeah. Yeah, you can't own any other percentage, but you don't really know to the percentage on title because they have an undivided interest. It means it cannot be divided. There is, if one dies, like imagine a sphere and they own the sphere. If one of the owners is not there anymore, the sphere goes to the other owner. It's together. It's not divided. Yeah.
Okay. Thank you so much for joining us here, because we are going to talk about the second half of this question next week. And that is, what would happen in each of these situations if someone were to pass away? So stay tuned. Can't wait to join you here back again, where we'll be discussing that. Thank you so much. For now, always like, comment, and share. Thank you.